Hello, everyone. Welcome back to EddieStyle channel. Welcome to another episode of Interviewing the Law, where I interview legal experts about their lives and careers, hoping to learn more from their experiences and wisdom. Today's guest is one of the most recognized names in a field that we all share deep love and connections to, the field of music, sports, and entertainment. Building himself from scratch, our guest today has worked with some of the biggest names in the industry. He earned numerous awards along the way, including being named as one of Billboard's top music lawyers for 6 years in a row. And he was named as one of Illinois' super lawyers, an award that is only awarded to a handful of lawyers from the entire state from all the fields each year. Beyond his legal practice, he's also teaching sports and entertainment law at Loyola University School of Law in Chicago, inspiring students to find their voice, find their niche and uniqueness, and bring real value and competency to the field. Please welcome to today's Interviewing the Law episode, Attorney Timothy Liam Epstein. Thank you so much for being here today.
Happy to be here.
This field is really something everybody needs on a deep level. Sports, entertainment, music. How does it feel like to work in such a field, and what do you generally do?
Well, I think it's important to distinguish between entertainment law and sports law. So if we take sports law first, sports has some distinguishing characteristics that are unique to sports. So we would call that the law of sport. And within the law of sport, there's things that you don't really see come up in other fields of law. So I'll do doping cases, I'll do eligibility cases, transfers, infractions, things of that sort. I'm passionate about it. I think there's a lot of good, serious people that are needed in the sports side as well as the entertainment side. And that's really why I broke into the field. You also have sports law where you're just dealing with clients who happen to be in sports, but you're just doing normal transactions that you would do with mergers and acquisitions or other contractual issues. Then you have entertainment law. Number one, make a division between live entertainment and recorded entertainment. Similarly, you could have art, studio art that produces works of art, paintings, sculptures. You could have recorded music. You could have some other types of visual art. But the space that I operate in is live entertainment. So it's not the recorded part. Why do I make that distinction? Well, I only work on the venue festival promoter side, on the live entertainment side. I don't do anything on the artist side. That's separate and distinct. And frankly, it's a violation of professional responsibility, in my opinion, to work for the buyers of talent and the talent itself. It's not tolerated in any other industry. You don't represent the pilots in the airline. You don't represent the truckers in the trucking company. You should not represent the performing artists and those that pay for the performing artists to perform for an audience. There really is no transferable skills between doing a record deal, a record label deal, and knowing what a stage or security contract should look like for a live performance. I don't pretend to do anything on the studio recording side, and my hope would be that no one on the studio recording side would pretend to do anything on my side of the fence. I'm passionate about it. I think there's a lot of good, serious people that are needed in the sports side as well as the entertainment side. And that's really why I broke into the field. Don't come into it as a fan. And I think a lot of people approach both sports law and entertainment law as a fan, which is fine, but the clients in the space deserve to be treated as you would treat a client in any other industry. I mean, how many attorneys get into working in natural gas because they're a big fan of natural gas? How many attorneys get into working on corporate real estate because they're a big fan of leasing out warehouses? But people approach sports and entertainment because they're a fan, which again is fine, but we need to be serious in this field. And I think when I came into this field 20 years ago, my goal was to be serious and to take it seriously and bring appropriate level of legal acumen and professional responsibility. And I think that's paid out relative to clients who want that. They want the expertise, but they also want someone who's serious about it. And then over time, you're able to get leverage as counsel for these clients because you've done it long enough and you know the players in the space. And I think one of the drawbacks that I consistently run into in both sports and entertainment is some attorney will come into a case and they're not willing to give up the work, even though maybe they're a bankruptcy lawyer or a real estate lawyer or a criminal defense lawyer. And by way of a family member or a friend or some other reason, they come across a case that's a high school eligibility case, or they have the opportunity to represent a comedy venue or a music festival, and they want to work on it because they're a fan and it's fun and it's sexy and they don't want to give up that work. And without fail, they end up screwing it up somehow. Listen, I'm not going to start doing bankruptcy. I'm not going to start doing family law. It's not what I do. And so if a client comes to me with a need in a specific field, I'm going to find the best person for that job, for that client, that makes the most sense. Obviously, if they can't afford an attorney who's billing out at $2,000 an hour, who's the expert on it, I'm going to try to find someone who may not be the absolute best, but is going to be the best for that situation.
So you have an option either to represent a talent or represent the venue. Why did you choose to represent the venue? And initially, what attracted you in sports and entertainment law?
My desire to work in sports law started when I was in law school. And I saw that there were some issues with how private and non-boundaried schools were getting treated by high school associations. And I thought that was something that needed to be addressed. My own high school was a private non-boundaried school, and I thought that the way that the high school associations were dealing with them across the country was something that needed to be addressed on a legal basis. I think it's difficult because a lot of the private non-boundaried schools tend to be some of the ones that are the most successful in their various states. But I feel strongly that it's not the purpose of a high school association to legislate wins by doing things like multipliers that continually add and boost up the level that a high school should be playing in, right? And doing things where there's assumption of things like recruiting that might be going on, that instead of going after that recruiting, there's broad-based situations where they're saying, we think that there's some level of recruiting, so we're just going to bump you up into a higher level of play. It just didn't seem to make sense to me from a legal standpoint. And so I approached that and drafted a second law review article while I was in law school, which then later I had published once I got out in my first year of practice. And that led me down a path of there seems to be other places within sports law where there's not the best legal counsel being given, or no legal counsel is being given at all. And a lot of that was relative to NCAA student athletes as well as Olympic athletes. They were just getting the short end of the stick. And I thought that I could step in and help. And so I did a lot of stepping in and a lot of helping. Obviously now in 2025, the state of the NCAA and how we deal with the athletes that are at colleges and universities, the NCAA term as student athlete, is very different. There's significantly more power given to them. There's a lot more money that's coming their way than there was before. So I was early on the scene and had a lot of defeats being early on the scene. The public, I predicted, was going to come around to giving more support to the student athletes once people realized how much money was on the table and how little of it was going to those student athletes. And so that was the path in sports law, and the practice has gone beyond that. My firm, we do a lot of work with athletes at the professional level, not on the playing field. And so I merged my kind of dispute practice on the sports side with my current law partners and their practice doing what I call bedroom to boardroom. So the wills, trusts, and estates work and personal counsel work and personal tax work for some of those folks, with the dispute side work, as well as the sponsorship side work that I have from my live event practice. So that's the journey on the sports side. On the live entertainment side, a friend of mine was starting a music festival right when I was getting out of law school. He was looking for some help with that. And so I ended up helping informally a bit on the side. And then once his original partners broke off on Intonation, and he then reached out to the folks at Pitchfork Media, and it became branded as the Pitchfork Music Festival, I came in to help there. I was helping reluctantly, frankly, because there were other areas that I wanted to break into and didn't think that this was one that needed a lot of help. But the more I delved into it, the more I realized that there was help that was desperately needed, that was focused on helping the promoters and the venues and the festivals, because there was a significant amount of legal resources being devoted to the artist side. And so through referrals, through meeting various folks with Pitchfork, they quickly, gathered up more clients on that side to the point where today, I think last count was 130 festivals I represent, over 100 promoters, and a couple hundred venues. And so with that comes the substantive expertise, but it also comes leverage that I have the ability to get a client a deal they may not otherwise get because I have the ability to use leverage across my client base to benefit all of them.
Early on, you exchanged dollars for experience, and
Right.
you said that you, even now, sometimes you work 7 times a week, and that it's not toxic. If you love it, you worked really hard. Can you tell us a little bit about that in terms of young attorneys trying to break into the field?
Sure. Well, I think the temptation, and I don't begrudge anyone for doing it, is to take the highest paying possible job you can take as quickly as possible to get that income, whether that's income you want to spend or it's income that you need to be able to pay off the ever increasing cost of a legal education. And a lot of folks may have debt carried over from undergrad as well. So I don't begrudge anyone from digging into it. But if there is the opportunity to strategically create a path within law that would allow you to work in a field that you find interesting, that's great if you have the ability to do it. But I specifically sought a path that was going to allow me to get a significant level of trial experience and then build up contractual law experience, corporate experience, so that I could be well rounded as counsel. But to get that significant trial experience early on, it was a pretty big pay cut relative to what my classmates were getting. At that point, my peers were starting off big firms making $125,000 a year. That was about top line when I was coming out. And I took a job that was making 70. So that required me to, frankly, my first year out of law school, I lived at home with my mom, and that was a sacrifice. Certainly, crashing with friends on the weekends in the city, but that was a sacrifice that I had to make to get on the path that I wanted to get on. And I've always been entrepreneurial, always wanted to start something and get to the top pretty quickly, and frankly, not have a boss. But that required me to get a significant level of experience so that I could myself take on cases where it wasn't just being in a major firm working as a third or fourth chair on a piece of litigation or, being the 10th man down on a deal, which again, not to begrudge that, that is a path and that is a way to make money and that is a way to serve clients and that is a way to become a lawyer. It's just not the path that I wanted to take. And so, yeah, it was giving up dollars to get there. Frankly, the breadth of clients that I do have to maintain that, it forces me to maintain a much lower rate than some of my partners at my own firm and a much lower rate than some of my peer group that I, you know, had from law school, as well as my peer group within entertainment and sports law. My rate is half of some of my peers. And I do that for the benefit of all my clients. Listen, you're not paying as much as other folks, but it allows me to represent some very small venues and promoters and some of the biggest ones on the independent side. It also allows me to represent folks who really need the help on the sports side, who couldn't otherwise be able to afford to pay for some of the services from some larger firms. And so it's intentional. There is money that is left on the table, but it's what I want to do. And this is the path that I've taken. And I don't think it would make sense at this point, to double my rate to catch up with my peer group. I would have to fire about 3/4 of my clients or they would have to fire me. So that's definitely not the route that I want to take. This is who I am. I serve my client base who I'm able to serve, and I want to continue to do so.
During the lecture that you gave us, you talked about the role of confidence in negotiations and settlement agreements. Could you tell us a little bit about how you see confidence in negotiations and settlements?
Well, I believe I said two things. It was relative to the confidence that you should carry going into that, but it's also about who has the juice, who has the leverage at a given point, which changes through the course of a negotiation. It changes through the course of a contractual relationship. So the level of confidence you have going into it and the specific deal points that you push on or don't push on are all generally relative to how much leverage you have at a given point. The example I give of if we talk about some of the championship teams from the Chicago Bulls back in the 90s, the guy who's number 10 on the bench, does he have more leverage than a local car dealership where he's going to serve as an endorser of that car dealership? Likely the car dealership may have more leverage, but if that car dealership was going to contract with Michael Jordan or Scottie Pippen, Michael Jordan or Scottie Pippen would have more leverage. And then you keep ratcheting up. Say it's a Ford dealer. Okay. Local. Obviously, Michael Jordan or Scottie Pippen's going to have more leverage there. What if we're talking about Ford generally, who has more leverage? Well, Ford generally is going to have more leverage than Scottie Pippen, but Michael Jordan at that point was arguably the most famous person in the world. So it may be Jordan has more leverage in that relationship from an endorsement standpoint. So it's a recognition on the part of who are you representing and what leverage do you have at that point, and is the leverage going to change throughout the relationship? And you push on various things that maybe you want. Maybe you push on things that you don't really want so you can give on that later so you end up getting what you really want. But it's an art. It's not a science.
I'm curious to hear your thoughts a little bit about the NIL. Do you think that the current system is more fair? Do you like the current system right now?
I don't think there is a current system right now. Name, image, and likeness relative to athletes when we're talking about those that are in college. There's various state laws on it. The NCAA has taken a position, but they cannot take a significant position, otherwise risk antitrust claims. So the federal government needs to come and step in. There is some legislation that's being proposed at the federal level. What happens to that eventually, we'll see. But the athletes should have the opportunity to profit off their own name, their own image, their own likeness. That's a new concept that's been adopted. Previously, the concept was basically the second that you sign on to participate in an NCAA sport, you're giving up your ability during your time at school to profit off your name, image, and likeness. And that slowly was chipped away. And now at this point, there is the ability to do that. And there is some compensation being offered to athletes from the past. And certainly there's dollar amounts on go forward. The question that I think needs to be resolved is whether we are going to be okay with pay for play. And if you're going to compensate someone for their name, image, and likeness, that's a different concept from paying someone to play at your institution. And we all need to be honest with ourselves that a lot of the NIL right now is compensation for participation at that institution, whether that be coming from the institution itself or from a third party. That's what it is. It is pay for play. Now, if we're okay with pay for play, let's just call it what it is. And if we're not okay with pay for play, then we need to be clear that we're not okay for pay for play, and the rules need to follow.
Now there's a new concept, the enhanced games. What do you think about that?
There was moves many, many, many years ago to prevent football players from working out in the off season because that was regarded as being a performance enhancement that would have not been available to all of them. If there was a professional football team that could afford to have their players not work as a salesman for insurance or alcohol in the off season and could basically just have them employed year round, and in the off season they were training, they were lifting weights, they were doing other forms of training, then if one team could afford to do that and another couldn't, that would have been an unfair advantage for the team that could afford to do that. Analogize it to salary cap, right? If you could pay someone anything you want to pay them, then you're going to be able to attract the best talent and money can buy, arguably. So there's always going to be the question of performance enhancement, what's permissible performance enhancement and what's impermissible performance enhancement. That debate has been going on forever. I imagine it will continue to go on. So if you have something called the enhanced games, you're allowed to do whatever you want. Are you allowed, can it be genetic enhancement? Is it just supplemental enhancement? Is it You're allowing drugs. What about we get to a point where, someone can have some bionic parts? Is that going to be permitted? Can you have bionic eyes? Can you basically be a cyborg? So the debate is going to go on relative to what we're going to want to see. And really, for a number of sports, it's not just the fairness among competitors, but it's what do we do with the record books? Do we asterisk everything? That's fine. I mean, the market will dictate what's going to be the most successful and what the people want to see. So let the market dictate. But if it's going to affect records officially within a sport, the body of that sport is going to need to chime in and say what they think is going to be permissible enhancement moving forward. Because I can tell you the difference just in a locker room for where I went to high school and for state champions in football versus the same high school state champions in football and what the athletes look like now versus then. There's a lot more six packs now. There's a lot of guys who can run faster. There's a lot more strength because training is different and the way people treat their bodies is different. And that is an enhancement. Should that affect the record books? It's not for us to decide, but someone at some point within the governing bodies of that sport need to make those decisions continuously. It's a constant source of debate.
We have an exciting summer ahead of us, the 2028 LA Olympic Games. What do you foresee the biggest opportunities or legal issues that could come during that Olympic Games?
You're going to have issues of, hey, we need to secure real estate contracts. We need to secure venue contracts. There's sponsor issues that comes up. There's broadcasting issues that come up. So many fields get touched, and the Olympics has the law of sport, like I talked about with doping and eligibility, but it also has sports law where it just happens to be sports entities that are involved in normal dealings. Maybe there's a sponsor who's unhappy with the amount of time they got on a broadcast. Maybe there's some medical issues that pop up. Maybe there's some other pandemic that pops up. And so there may be intergovernmental issues. There may be immigration issues that are going to pop up. We'll see what continues to happen with immigration enforcement in the United States. That would not just be limited to the participants, whether as athletes or trainers or coaches or other team staff, but with fans and how they're allowed to travel and come to various events, and what are going to be the implications of that for future games if various countries feel that they've been mistreated by U.S. authorities on their ability to send their athletes and their team representatives and their fans. So it's really going to touch on just about everything you could think of. Olympics is a bit of a microcosm. When that comes in, you get really touches on almost every issue.
What are your thoughts on AI being able to produce music quickly and its effect on the music industry?
I think there's always going to be a demand for human-made things. There's always going to be a demand for things that are bespoke and created by humans. There's going to be a lot of content that's going to be produced by artificial intelligence. And I think the consumer is going to dictate what they want. And if they prefer something that's produced and performed by an actual human, great. Musicians have been using Pro Tools for a while now. They've been using enhancement in their own production, maybe getting some help on the songwriting side as well. So I don't see that as so new, but I think what will be different would be almost the absence of a human in the process. That's the new thing. But there's been technological assistance for musicians and songwriters and producers for a while now. So to completely divorce the human from the process, I think that's novel. Whether it's something that people care to listen to, I think the consumer is going to dictate that. And I don't think we have anything that we're going to be able to prevent the creation of that product. It's now whether or not that's a product that's worthy of protection under the law. Is it worthy of copyright protection? If no human took place in, well, who's going to own it? So I'd be interested to see how that's going to shake out. And I think a lot of folks that are within copyright law are still trying to sort out how that works.
Are you ready for our Eddie-style question round?
Sure, Eddie.
So when do you need to clear your head and just get some thoughts out? Do you have any ritual that you use? Any place you go?
I work out a couple hours a day every day. I don't do caffeine. That's my place that I go. So it's going to be at the gym. It's going to be on the sand playing volleyball. It's going to be playing platform tennis. It's going to be on my paddleboard. It's going to be one of those places. That's where I clear my head every day during the workouts.
Why don't you do caffeine?
Just don't really have the need for it. I don't get tired a lot. I tend to get good sleep, and I naturally have a level of energy that doesn't really require the caffeine.
That's terrific. What's your favorite Chicago food?
Chicago food or food that's located in Chicago? I think those are two different things.
I'd say food that is located in Chicago, perhaps.
It's tough. I'm not a deep dish pizza guy. Maybe I'll have one piece a year and generally feel awful after I have it, but it tastes pretty good going down. I like a good hot dog. I like a good Italian beef, but those aren't things that I really crave and go after. Those are very rare things. I tend to, you know, eat eat fairly clean. And if I'm gonna cheat, it's what's gonna be there, after I've had a couple beers. So if it's gonna be a hot dog or an Italian beef or pizza, I'll go for it. But I just as soon would go for a burrito.
Now, let's imagine we have a time traveling machine and you could go to any sporting or music event in history. What would that be? Front row, of course.
I think part of the difficulty on the music side is the experiences and the level of production and the sound has gotten a lot better. The example that's constantly used is when the Beatles came to America and they played at Shea Stadium where the Mets play, and they put the music through the PA system that was existing for baseball. That's not a great experience. It's cool to see the
Mm.
Beatles, but I want the sound quality to be good. So I don't think there's a lot of uh, time travel back to see certain things because of the quality of the sound. But I think I would have liked to have seen um, Led Zeppelin, in their top of their game, or see the Beatles top of their game. I think that just would have been a pretty cool experience. But from a sound and a production standpoint, you're not going to beat what we currently have. From a sports standpoint, that's not even close to being as dramatic as music because you're seeing the product on the field while the experience of a fan is significantly better now. I think it would have been, I would have liked to have seen in person. I think it would have been cool to see the Bears win the Super Bowl in '85 in person. I watched it on TV when I was a little kid, but I think that would have been cool to see in person. But not much else. The fan experience that you get today is hard to beat.
Is there a principle that you've been living by that guided you throughout your life?
There's multiple principles that I've lived by to guide my life, but I think it's being honest with yourself and being honest with other people. I was in Nashville for a live music meeting last week, and a friend of mine in the business introduced me to someone else, and he asked me what I did, and my friend cut me off and said, he's a lawyer. He said, he's the most ethical lawyer you'll ever meet. Not that that's the first thing that a client wants. What do you want out of your lawyer? I want the guy to represent me the best way possible. I want him to win. I want him to get me the deal. Ethical is not the first thing they say, but I thought that was a nice compliment.
That's great. Well, Attorney Timothy Liam Epstein, thank you so much for joining EddieStyle and interviewing the law. This is the third time that I've heard you speak. I read a lot about you. You are definitely very motivated. I think you have a very strong character and you inspire people and continue doing what you're doing. And I'm wishing you all the best.
Thanks, Eddie. Happy to do it. Good luck with everything. Take care.